Hearing the appeal of Secretary of State for Business and Trade against Mercer.
Mr. Ford.
Yes, my lords and my lady. I appear on behalf of Mrs. Mercer with Mr. Brittenden and Professor Bogg. And for the intervener, Mr. Stillitz appears with Ms. Starks. As my lords and my lady will know, the respondent to the tribunal proceedings appeared in the tribunal, appeared in the AT, but has taken no further part in these proceedings. So the intervener is the effective respondent. Now, I hope the court has received our email about the envisaged timetable. The proposal is that I will go on till 2:40 today, but with 10 minutes injury time or added time, if that's acceptable. But if I do go on extra, that will come off my reply.
You can run into your time for reply.
I'm very grateful, my lords. And then the idea is that Mr. Stillitz will then go on till 12:30 tomorrow, and that I get a half-hour reply, subject to any deduction.
Yes.
I hope the electronic bundles are all working. I hope too, my lords and my lady, received a copy of the ICR report of Drew. Unfortunately, the IRLR was in the bundle, and the translation of the Caesar case, Caesar and Turkey case.
Not sure about the last. Yeah, we've got that, I think, in the bundle. We have, right.
Yeah, they were both in the same email. Caesar is in the bundle, but only in French.
That's right. And it may assist if I say that we're all working off electronic copies, not hard bundles. I don't know if Mr. Stillitz is.
I'm not, but I have cross-references to it
Right.
to hand.
Yeah. So we'll need the reference to the bundles as well.
I'm only giving electronic references, my lord, so my lady. The time is short, so I'm taking the judgments below as read and the cases as read as well. And as my lord and my lady knows, there are 3 grounds of appeal here corresponding to the 5 issues. I'm going to spend most of the time this morning on ground 1, corresponding to issues 1 to 3 on the scope of Article 11, because that's where there's most disagreement about the principles. But then I'll say, obviously I'll address Section 3 HRA and say something about Section 4 HRA, although that's mostly set out in full in our case. So the brief structure of the submissions, I'd just say a few introductory words about the facts and the statutory framework, then Article 11, then Section 3, and then Declaration of Incompatibility. And as my lords know, the tribunal dealt with this case on the assumption that the facts asserted in Mrs. Mercer's claim form were true. Can I just highlight 4 matters about the facts? The first was that Mrs. Mercer was a support worker and a union representative who represented Unison in collective bargaining and was involved in the planning of the industrial action. The second matter is that the strike was organised by Unison, which is an independent trade union, and it took the form of discontinuous strike action in respect of overnight shifts on certain dates. And the substance of the strike was about the removal of members' top-up payments at the employers' care homes and elsewhere, and so it constituted a trade dispute. It was also called in compliance with the rules on balloting. In other words, in summary, it was primary industrial action, it was lawful industrial action, it was official industrial action, and it was protected industrial action. The key detriment on the assumed facts was her suspension between the 26th of March 2019 and the 13th of April 2019. At the time she was suspended, she was not taking part in a strike, but a strike had taken place recently on the nights of between 2nd and 4th of March and between 18 and 25th of March, on each day from between 10 p.m. to 7:30 a.m. In other words, the workers would work during the day, but then the strike would take place during what would be the sleep-in shifts. And strike action was due to take place on the 5th of 6th of April the 8th and 10th of April, and in early May. And as my lords and my lady will have seen, the suspension prevented her contacting her colleagues connected with the allegations or entering the employer's premises without permission. And for the court's note, the relevant suspension letter is at EF 278, but I'm not going to turn to that. In addition, she didn't receive the overtime supplement she would have received if she'd worked normally. And that's in the Statement of Facts and Issues at paragraph 7. And finally, the fourth matter for the purpose of this appeal, the purpose of the suspension on the assumed facts was to prevent or deter her and others from taking part in the forthcoming industrial action or to penalise her for having done so. And that's that Statement of Facts and Issues, paragraph 17, EF 51. In fact, on her pleaded case, it was also that it in fact deterred her and others from participating in the strike. So that brings me to the statutory framework. Now,
so can I just be entirely clear? It's not the case that the shifts that she didn't attend were when she was on strike. That's not part of the factual assumption.
Sorry, I've slightly misunderstood my lord's question.
Sorry. As I understand it, she didn't attend certain shifts.
Well, the pleaded case was she was deterred from and others were deterred from participating in the industrial action. The industrial action was not attending the shifts they would have attended. So the form of the industrial action, the participation, was not.
So her failure to attend the shifts was because she was on strike?
Yes, correct.
Okay. That was not my understanding of the facts lower down, but that's fine.
Yeah.
If that's agreed.
She hadn't taken part in the strike action. The only reason she didn't attend shifts was because she was suspended afterwards, and the suspension was to deter.
No, she had taken part, correct? Yes, she had taken part in past strikes. She had participated.
But not in this one.
Yes, no, in this strike action, she had participated, yes. Yes. And it's ET 14. Her activities encompass the planning and organisation of the industrial action and her own participation in it. That's electronic file 221. Now, the relevant statutory provisions are conveniently summarised in the judgment of Regional Employment Judge Franey at paragraph 27 and onwards. That's at EF 222. To 224. So I'm not going to go to those now. They're conveniently summarised for my lords and my lady, including the relevant provisions on unfair dismissal. There's just a couple of matters that I should amplify for my lord and my lady's note. First of all, paragraph 36 of the tribunal judgment at EF 224 referring to section 237, the question there is based on whether the employee was taking part at the time. That's a time question. It's not a causal question, it's a temporal question. Secondly, section 238, the exclusionary rules, that's whether or not the employee was taking part in the official industrial action at the date. So that again is a temporal question, but it's date. And thirdly, over the page, section 238A, the employment judge says, in relation to that provision, such dismissals are automatically unfair during a protected period of 12 weeks. That's not quite accurate. And I tell my lords and my lady what the position is, that there is a protected period of 12 weeks after the action started. That's position one. But secondly, if the employees have stopped taking protected action before the end of the 12-week period, but are dismissed afterwards, the protection continues indefinitely. So it's not simply a 12-week protected period.
Striking beyond the 12-week period, which triggers the particular consequence, is that right?
Well, there are three positions. Position one is when you're dismissed within the 12-week period, which is automatically unfair. Position two is when you're taking part in a strike and you stop before the end of the 12-week period, but you're dismissed afterwards. And that protection continues forever. And then the third position is where you haven't stopped taking industrial action during the 12-week period, and continue afterwards, and are dismissed afterwards. Then the protection continues if the employer failed to take reasonable procedural steps to resolve the dispute. So those are the three positions.
And that's all set out in the legislation?
Yes. The relevant subsections are 4 and 5 for the last two. Yeah. So, my lords, without further ado, can we turn to Article 11 then? And we say the principles that are derived from Article 11 are summarised in our case at paragraphs 40 to 56. That's EF 484. And we say the following is crystal clear from Strasbourg. Firstly, Article 11 protects individuals who are subject to sanctions, however light, the purpose of which is to dissuade them from participating in lawful strikes organised by their union to defend their professional interests. And by lawful strikes there, I mean lawful as a matter of domestic law. Secondly, in the case of lawful primary industrial action, that is industrial action where the dispute is with the employer against whom the strike action concerns, such sanctions have an inevitable chilling effect, as the cases beginning with Carasay, no doubt mispronounced, show. We say such restrictions strike at a core trade union activity of taking collective action to protect the members' interests, of which striking is an example. And Article 11 gives protection to the individuals and union officials who participate in that form of trade union activity, just as it protects participation in other forms of lawful trade union activity. Thirdly, it makes no difference whether the sanction is applied directly by the state or is in breach of the state's positive duty to provide effective protection horizontally. See our case at paragraphs 40 to 42.
Just before you go on to that point, does it make any difference whether the individual who is striking under what is an official strike is or is not a trade union member?
Well, the right in Strasbourg is as you'll note, is a right to form and join members for the protection of your interests. So, of course, Strasbourg might protect via freedom of assembly non-members, but in terms of the trade union activity we're concerned with, it's only trade union members who are protected. because it's their right to form and join trade unions. It's that constitutes a trade union activity. And we'll see from the case of Barris and Turkey that Strasbourg has said a strike is only protected under Article 11 insofar as it concerns action by a trade union.
But our domestic law would protect people who are dismissed, irrespective, provided the strike's official, irrespective of whether they're trade union members.
Yes, yes.
But you're saying Strasbourg doesn't go that far?
No, Strasbourg says a strike is a form of trade union activity, see Barris, and therefore and it's only strikes concerned to protect the members' occupational interests, and therefore it is protected as such.
It's protected, but has Strasbourg said it's a core element of trade union activity?
Well, we'll come on to that when we look at the RMT case.
But at the moment, you're just saying it's protected.
To anticipate our submissions, we say a primary strike is a core trade union activity. And we say that the RMT case, properly analysed, demonstrates that. Now, before I turn to the cases, just 3 preliminary remarks. Firstly, the Court of Appeal accepted that, at least in some circumstances, UK law was already in breach of Article 11, even in a private sector case, focusing on the extremes of dismissal, suing workers for damages, or an indefinite suspension on nil pay. The Secretary of State, it seems, won't even go that far. But we say that the Strasbourg case law in this context has never focused on the kind of detriment. Rather, it has consistently focused on whether the sanction, however minimal, was a dissuasive one imposed because of participation in a strike or other lawful trade union activity. The distinction between extreme detriments and lesser detriments is not found in the case law, is not found in the decisions of the expert bodies on Article 5 of the European Social Charter, or ILO C98, to which the court has repeatedly referred, and is not, we submit, a principal distinction at all. There is no explanation by the Court of Appeal why some detriments are impermissible but others are not. Secondly, we say it's telling that neither the Court of Appeal nor Mr. Stillitz addresses whether the sanction imposed on Mrs. Mercer would have resulted in a breach of Article 11 if she were a carer employed by the state, for example, in the NHS. And we submit there is only one possible answer to that question in light of the cases beginning with Carasay. We submit her suspension would strike very directly at the core or very substance of the trade union activity protected by Article 11. But we say the core trade union activity is the same, whether it takes place in the public or private sector, and so is the nature of the restriction. Contrary to the Secretary of State, no case indicates that the core trade union activity of acting to protect its members' interests is different in the public or private sector. Every case says it makes no difference. Thirdly, and again contrary to the case for the Secretary of State, no case indicates that only sanctions which target trade union membership or the making of representations on behalf of a union are part of the core which the state owes a duty to protect. Rather, the cases show that the right to form and join a union is much broader than that, and the core union activities protected by Article 11 include participation in lawful collective action to protect the collective interests of the members, of which primary industrial action is an example. So against that, those opening remarks, can I turn to some of the cases? My Lords, you'll see the various statements by the, my Lords and my Lady, the Strasbourg Court about the right to strike being an important means or an important aspect by which unions protect their members' interests. That's in Ognevenko at paragraph 56 EF 1054 and Ognevenko paragraph 70 EF 1056, but I'm not going to go those now.
Reference again, the paragraph references again.
Ognevenko 56 at EF 1054 and Ognevenko 70 at EF 1056. And then to address the point my Lord Burrows has raised, the Barris case, just to give you the reference, it's summarised. Barris is at tab 19 EF 3835, but it's summarised in our case at paragraph 26 EF 68.
Paragraph again.
Paragraph 26 of our case, EF 68. And that case says that from the perspective of Strasbourg, members who participate in a lawful strike called to protect their professional interests are participating in a legitimate trade union activity. And the corollary of that is that strikes are only protected under Article 11 insofar as they form part of a trade union activity. So the right to strike is restricted to trade union activities. And for that reason, we submit that the protection Article 11 gives to individuals participating in a strike must be seen in the broader context of the protection that article gives to participation in lawful trade union activities. And in essence, we say the principles overlap. That sanctions dissuading members from participating in lawful strikes are no different from other sanctions imposed on them for engaging in other forms of lawful trade union activities. And can I just refer briefly to three cases? The first one is Wilson, if we could just turn that up. It's at tab 33, but EF 1170. And I think my Lord Lloyd Jones and Lord Richards will be familiar with this, and Lady Simler at different stages of the litigation in Costill. Sorry, Lord Burrows in Costill. Lord Burrows and Lady Simler in Costill, Lord Lloyd Jones and Lord Richards in Deliveroo. But this was the case concerning where private sector employees were denied pay rises given to their colleagues if they didn't sign contracts outside of collective bargaining. And the court, at paragraphs 30 to 37, for my Lord's and my Lord Lady's note, you'll see makes extensive reference to the European Social Charter and the provisions of the ILO conventions, including 87 and 98. And we say that's a recurrent theme of this case law, reference to Article 5 of the European Social Charter and ILO conventions, particularly C98, and that the Strasbourg case law here is in harmony with the ESC and the ILO convention. The crux of the court's reasoning is at paragraphs 45 to 48 at page EF 1177. And one sees at 45, the court acknowledges there were other measures available to the union by which they could protect their members' interests, and they refer in particular that they did have the right to strike, which they refer to as one of the most important means by which the state secures a union's freedom to protect its members' occupational interests. At 46, they talk about the essence of a voluntary system of bargaining, saying that it must be possible for a union which is not recognised by an employer to take steps, including, if necessary, organising industrial action. And then talk about the essence of the right to join a trade union as encompassing the freedom to instruct or permit the union to make representatives to their employer or to take action in support of their interests on their behalf. So the essence includes the union taking action in support of their interests on their behalf. And go on to say it is the role of the state to ensure that trade union members are not prevented or restrained from using their union to represent them in attempts to regulate their relations. Referring at 47 to the position under UK law, and then said, picking it up halfway down the sentence, the corollary of this was that United Kingdom law permitted employers to treat less favourably employees who were not prepared to renounce a freedom that was an essential favour of union membership. Such conduct constituted a disincentive or restraint on the use by employees of union membership to protect their interests. And my lords and my lady, we draw attention to 3 points from Wilson, which we say are echoed in the later cases. Firstly, nothing prevented Mr. Wilson or the other applicants from forming a union, being members of a union, or using the union to make representatives on their behalf, including by strike action. But the existence of a disincentive or restraint on using their membership to protect their interests, including by collective action, was sufficient for a breach. And we say this is because the protection of Article 11 has never been restricted to the empty right to hold a membership card. The right is linked to the union acting collectively to protect the members' interests. And we say this foreshadows the approach in the strike cases where the court holds as impermissible sanctions those which are intended to dissuade, have a dissuasive effect on members taking strikes. So we say that echoes the reference to disincentive or restraint. Secondly, Wilson emphasises that the state owes a positive duty to secure that result. There is no reference to the margin of appreciation in relation to protecting the individual against disincentive of restraints. No reference to a wider margin of appreciation because the applicants were here all in the private sector. And we say that too is a recurrent theme. And thirdly, the point I've already touched upon, there is close harmony here between the ILO Convention C98 and Article 5 of the European Social Charter. And you see that as reinforced by paragraph 48 of Wilson, where the court, having concluded that United Kingdom law therefore was incompatible with the positive duty because it could undermine or frustrate a trade union's ability to strive for it, refers to the criticisms by the ILO CFA and the European Committee of Social Rights to enforce its conclusion. Yeah. The next case I'd like to turn to is Danilenkov and Russia.
Just before you leave that, you're saying there's nothing about a margin of appreciation at all in Wilson, is that right?
Well, they do. They refer to margin of appreciation when it, at some stage in their assessment.
Right.
Yes, it's at paragraph 44. Talking of a wide margin, it's at the bottom, my lord, a wide margin as to how the freedom may be protected. But when it comes to the substance of the decision, there's no reference to a margin of appreciation. They simply say, is this a disincentive or restraint? Therefore, the UK owes a duty to secure that result. Therefore, it failed. Nothing about a differential standard because this is in the private sector. And no discussion of Article 11.2 either. And we say that's all of a piece with the strike cases, because whatever the boundaries the state has in setting the parameters of lawful industrial action, no doubt it has a wide margin then. When it comes to protection of the individuals who are within the perimeter fence, the margin reduces to vanishing point. And we say the same, you can see the same themes in Danilenkov and Russia, which is the second case I want to turn to. And this is at tab 26. Sorry, EF 873.
Page what, sorry?
873.
Thank you.
And you can see from the head note there at H1 that the trade union called a 2-week strike over pay and various other matters. And subsequent to that, there was a campaign of victimization of the union members. And they were caught on the... They couldn't bring... The civil courts lacked jurisdiction, and the criminal authorities declined to prosecute, so they ended up in no effective remedy.
Was it a public or a private employer?
Well, my lord raises a pertinent point, because it was in fact in dispute whether it was public or private. And if I can, if you turn to paragraphs 11 and 12 to start with in the judgment. That's at page EF 877. My lord will see that on the one hand, the applicants at 11 were saying this is a state body, whereas the state was saying it was a private body. So there was a dispute. And since we're dealing with it now, it may be convenient to see how the court dealt with that, because if one turns on to EF 893, you can see at the bottom of paragraph 118, picking it up at 116, the applicants were saying that the state had been involved because it directly controlled the Kaliningrad Seaport Company. That's 116. The government contested that. You can see that at 118. And the court resolves it at 120 by saying it's not necessary to rule on this matter because the positive obligation of the state will be engaged in any event. And you'll notice in footnote 9, it's back to our old friend Wilson. So that's picking up the second theme, that there is no difference of approach here, whether it's viewed as a positive obligation or a direct interference.
Is that a general proposition, or is it on the facts of this case?
Well, we say in all of the cases concerned with trade union detrimental treatment because of trade union membership, activities, or the right to join, whatever, the court has never adopted a different approach depending on whether it's a private sector body or the state. It's always said the standards to be applied do not differ in substance.
Was Danilenkov about Article 14 discrimination met with Article 11, or was it about Article 11 on it?
There was a complaint about the complaint was about both Article 14 and 11, but the court in fact said, and we'll come on to this very shortly, that doesn't matter because the right in Article 14 is integral to Article 11. So it doesn't matter whether you view it through the prism of Article 11 and 14 or solely through the prism of Article 11, the outcome is the same. And
where's that?
That paragraph for my lady's note is paragraph 123. So if you go over the page, my lady will see that picking it up halfway down 123, the wording of Article 11 explicitly the rights of everybody, and this provision obviously includes a right not to be discriminated against for choosing to avail oneself of the right to be protected by a trade union. Given that also that Article 14 forms an integral part of each of the articles laying down rights and freedoms, whatever their nature. In other words, Article 11 is integral to Article 11. And for what it's worth, that echoes the approach taken in all the other cases in this area, such as Carasay, where the complaint was brought under both Articles 11 and 14, and the court said it doesn't matter, we'll examine it solely under Article 14. And that's the case of many of the strike cases. They've said, well, Article 11 and 14 will examine it under 11. But just going back to Danilenkov earlier in the judgment, the court will see at paragraphs 1 and 2 and following, that's beginning at EF 889, the court refers to Article 5 of the European Social Charter. They refer to the revised one, but the wording's the same in the earlier 1961 one. And you can see they refer to decisions of the European Committee of Social Rights at paragraph 103. And in particular, 5 lines down, trade union members must be protected from any harmful consequence. We draw particular attention to that because we say that there is no scale of detriments in these cases that trade union membership or activities may have on their employment, particularly any form of reprisal or discrimination, and go on to cite various examples, because they belong to a trade union or engage in trade union activities. And where it occurs, domestic law must make provision for compensation that is adequate and proportionate to the harm suffered. So not just a right to some remedy, a right to a civil remedy. And they repeat that at 104. And we say this is exactly the same as the position in the strike cases. And the Court of Appeal is wrong to have looked at a sliding scale of detriments here. It's any harmful consequence. And they similarly refer to the ILO over the page at 105 to 107, where you can see the text of ILO Convention 98 set out at 106. And that is the convention that the forerunner of Section 146 of TOLCA was intended to give effect to.
Sorry, what was the reference? I apologise.
106 is the paragraph, my lord. Where the convention itself talks about adequate protection against acts of anti-union discrimination, and at B talks of dismissal or otherwise prejudice a worker by reason of membership or activities. And then at 107, various principles derived from the Committee of Freedom of Association about anti-union discrimination and the need for effective protection at 818. And when it comes to the court's conclusion, which we've already quickly looked at 123 and 124, on the effect of these provisions, well, perhaps it's at EF 895. Perhaps I can ask my lords and my lady to just quickly cast an eye over those paragraphs.
Which paragraphs?
123 and 124. We've already quickly looked at 123. Yeah, and my court's note, Mr. Brittenman reminds me they return to it at 136 when it comes to their conclusion. So we say, firstly, it doesn't matter if the complaint is brought under Article 11 or 14 to address the point raised by my lady Simler. And equally, we say, consistent with the point raised by my Lord Burrows, this isn't a margin issue again. It's simply a duty to secure effective protection for the individual participating in the activities. Now, it's true they're only referring to membership at that point, but they equally at 124 talk about discriminatory treatment, echoing precisely what the ILO Convention C98 says, which they'd referred above at paragraph 123. In summary,
I'm sorry, what have they... Oh, I see. Yeah.
They refer above to the CFA, my lord.
Yes, they do. Yes, I see.
Talking about discrimination on grounds of trade union membership, but the CFA provisions equally apply to activities. In other words, we say while the state may have a wide margin of appreciation when it comes to deciding what are lawful trade union activities, consultation over redundancies, compulsory collective bargaining, the parameters of lawful strikes, and so on, that's a wide margin, as you'd expect, because it's a socio-economic question. But when it comes to the protection of the individual against discriminatory treatment for participating in those lawful activities, the margin is reduced to vanishing point. The third case I want to refer to, but only briefly, is Straum and Latvia. That's at EF 1130. And my lords and my lady, this is a trade union activities case. Mrs. Straum was an air traffic controller and a trade union officer, and she'd made allegations that her employer was infringing employees' rights, and then she was subject to various detriments, including being suspended from her post on full pay. For the court's note, you will, once again, at paragraphs 55 to 8, I won't go to these, you will see extensive reference made to the ILO materials, including the Parallel Convention Protecting Worker Representatives, C135. So that's paragraphs 55 to 58. Secondly, this is our mea culpa moment. We apologise to the court that when we referred to paragraph 71, saying the restrictions strike at the core, we were wrong. That's not part of the court's analysis.
It's a submission.
I think it's a submission for the applicant.
And
Yes.
you wrote a letter to the court about
Yes,
that.
and I apologise.
We're grateful.
I apologise for that. But we do say it's self-evident that suspending a union official, above all on the terms which prevent her associating with her colleagues or entering any of the workplaces, is self-evidently a restriction which strikes very directly at the core of Article 11. It actually stops association. Now, the court's analysis begins at EF 1140, and I'm only going to skim through this quickly, but the reason I'm doing it is to show you that the court is applying the same principles as in the strike cases. For example, if you see at paragraph 89, it talks about the objective of freedom of assembly and association and cites Ezelan. And Ezelan is the very case that ends up feeding into the strike cases. At paragraph 91, it talks about the union must be free to strive, this is about a third of the way down, must be free to strive for the protection of its members' interests, and they have a right to be heard, citing Ognevenko and our old friend, which is a strike case, and our old friend Wilson. And at paragraph 92, towards the end of that paragraph, they say right at the end, even minimal sanctions dissuade trade union members from freely engaging in their activities. See Alton and Turkey. Now, we don't have Alton and Turkey in the bundle, but the paragraph they refer to in Alton and Turkey cites Karasay. At 102, two-thirds of the way down, the court explains that advocating for the interest of trade union members is the very function of a trade union representative and constitutes a fundamental element of trade union freedom. We say that captures Mrs. Mercer's position perfectly.
Sorry, that's paragraph.
Paragraph 102.
Thank you.
Just about two-thirds of the way down. And at 111, the court additionally notes that the detriments imposed on the applicant were in themselves capable of having a chilling effect on trade union members, referring to Ognevenko, paragraph 38, which is the paragraph in Ognevenko which refers to Karasay and all the strike cases. And although there's a passing nod at 112 to the court's subsidiary role, they simply end up saying they weren't compatible with the strict requirement for pressing social need and so on and so forth. Nothing about a wide margin. So we say Stroud shows two things. Firstly, the close overlap between detriments imposed because of participation in a strike and those imposed because of participation in ordinary trade union activities. The case law applies one to the other. Secondly, in both contexts, detriments which are imposed because of participation in those activities, including strikes, are not compatible with Article 11 because of their inevitable chilling effect. And we ask this court to suppose Ms. Stroud was suspended because of participation in a lawful strike. We say it's obvious the answer that Strasbourg would give you. And that, my lords and my lady, brings me on to the strike cases. The series begins with Ezelan. I'll just refer to that briefly. It isn't a strike case, but it's partly to show we're not the only ones who make mistakes. If I can turn to EF 990.
Which tab?
It's tab 24. About as outrageous an interference with human rights as you could imagine, because it's a warning given to a barrister. And although it's not a strike case, it feeds into the strike cases. And the critical paragraph is paragraph 53. Now, this is one of the old cases where at one time there was still a commission in operation at this point. Can I just pick up at one factor? If you go to page EF 1007, paragraph 51, the commission referred to the margin of appreciation. Now, in their case, Mr. Stillitz and Ms. Slark say at 64 the court referred to the margin of appreciation. That, with respect, is a mistake. It was the commission that referred to the margin of appreciation. And the critical paragraph in the court's judgment is 53, which is at page 1017. The court doesn't refer to the margin. The dissenters do. But you can see the words given by the court at the end of 53. How the right cannot be restricted. And that's the paragraph that then feeds into the strike case.
Sorry, which page are you on?
1017.
1017, sorry.
You may be looking at the commission. It's confusing because the paragraph numbers repeat themselves.
So you're paragraph 53 on page 1017.
Yes, my lord.
Thank you.
Sorry, paragraph 53, which is the passage that you're...
It's the last sentence. Cannot be restricted in any way. And that's the paragraph, albeit in another context, that then feeds into the strike cases. Now, the cases are all summarised in our case at paragraph 33, perhaps at undue length. That's EF 72 to 77. I haven't got time to go through them. But we say in outline they show the confluence of two confluence or synergy, however you describe it, of two principles. On the one hand, the principle from Ezelan on freedom of assembly, and on the other, the cases on individuals not being subjected to detriment for participation in lawful trade union activities. And we submit the court should note three features before reading these cases. The first is that in almost all the cases, the workers weren't prevented from striking, and often they did, in fact, strike. But consistent with Ezelan, the court rejected any argument this meant there was not an interference, however light the sanction. And can I just give you some references for that? See Dillek, paragraphs 55 to 57, EF 933. See Enahi Yapi Yol Sen, paragraphs 21 to 24, EF.
I'm awfully sorry. Can you just start your references again?
I'm sorry.
Yeah.
I've got the usual appellate advocates problem. Dillek, 55 to 57, EF 933.
Thank you.
Enahi Yapi Yol Sen, 21 to 24, EF 975. Kaya and Sehan, paragraph 24, EF 2750.
Paragraph 24.
24, EF 2750.
Thank you.
Secondly, in this context, the court has never heeded arguments that Article 11 does not require any particular trade treatment of trade unions or their members.
Sorry, what was your first point, relying on those cases?
That in almost all cases, the workers weren't prevented from striking, and often they did, in fact, go on strike.
Yes, thank you.
And the second?
Secondly, the court in this context has never heeded arguments that Article 11 doesn't require any particular treatment of trade unions. C.E.G. Enahi Yapi.
You're going to have to bear with us.
Sorry, I'm going
Never
to.
heeded argument. Just what's the proposition, please?
It's never heeded arguments that Article 11 does not require any particular treatment of trade unions.
Can you
or their
put
members.
that positively, or are you just saying
Well,
it's never accepted the argument?
It's never accepted. It's simply said it's Ezelan, it's a sanction, it's dissuasive, end of story.
I'm sorry, I don't understand the submission as you formulate it.
Well, in some of the cases, the argument is made. Article 11, you can protect Article 11 rights in various ways. You may have other means of protecting your interests. Therefore, why do you need this protection?
So you may have an ACAS disciplinary code.
You may be able to make representations to employees. You may have all sorts of other mechanisms by which membership.
That didn't work.
That
The court
doesn't
never
work.
accepted those arguments.
And the example is Enahi Yapi Yol Sen. See the argument at paragraph 29, EF 978. And the decision at 33, at 30, paragraph 32, also EF 978.
It's the judgment at
It's paragraphs 29 and the argument and the decision at 32.
32.
Thirdly, and by the same token, the court has never referred to the margin of appreciation when it comes to sanctions on individual strikers. Nor has it ever considered it to necessary.
Sorry, bear with us if we can. The court never refers to the margin of appreciation.
When it comes to sanctions on individual strikers. nor has it ever considered it necessary to examine whether the sanction pursued a legitimate aim. Even assuming there were such an aim, so long as the sanction is imposed because of participation in strikes and its purpose is to dissuade, the ineluctable conclusion is that it is not necessary in a democratic society.
You only get necessary in a democratic society if it does pursue a legitimate aim, don't you?
Yeah, but in several cases in Turkey, they said, well, it's not necessary to decide that question,
Okay.
even if we assume there was one.
Okay.
Whether it was defence of public order, doesn't matter, because it's a dissuasive sanction. And so can I just show you one of the cases in the time, which is Karasay. And that begins at EF 1037. And the English translation at, the English translation at 1037. So you can see at paragraph 7, there was a striker slowdown from a break from work. Paragraph 17, the court, just in all the other cases, such as Danilenkov, refers to Article 5 of the Charter. To show the point that I've already addressed to my lady Simler, you can see at 18, although the breach was invoked through both Articles 11 and 14, the court simply examined it through the standpoint of Article 11 alone, echoing the same approach in Danilenkov that it doesn't matter. 28, even though this is just a warning with no consequences, the court says it's an interference.
Paragraph?
28, page EF 1042. Paragraph 32, echoing the point I've already made, not necessary to see if it pursues a legitimate aim. Makes no difference. Paragraph 34, the government observed the applicant is still a member of the trade union, so they're trying to argue, as Mr. Stillitz does here, Article 11 is only about protecting your right to be a member. Paragraph 36, strike was announced and wasn't prohibited. In other words, it was lawful. And then paragraph 37, the conclusion, which is the which, if I can ask my lords and my lady to read that, that becomes a conclusion that feeds into all the other cases.
Who was the employer in this case?
The employer was the state.
Thank you.
And it's citing the paragraph in Eslam. And it echoes, of course, Wilson, because it's now dissuasion rather than disincentive or restraint. My lords and my lady, I haven't got time to go to the other cases.
Sorry, paragraph 38 takes us back to necessary in a democratic society.
Yeah. So it's saying even if there were a legitimate aim, it's not necessary in a democratic society. And my lords, then, and my lady, the other cases I won't return to. The one I do want to spend a little time on is RMT, just because of the weight Mr. Stillett's places on that. That begins at 1061. So here there were two challenges to the legislation. Firstly, in the EDF claim, the union complained about the ballot notice requirements. And for the court's notice at paragraph 45, where that was dealt with, where the court dismissed that claim. Page 1069. And for what it's worth, we accept, in light of that ruling, and the Trofim-Chukin Ukraine case, coupled with the mirror principle of Ulla, that it is only sanctions, Strasbourg only protects sanctions in relation to lawful domestic strikes.
Sorry, that Strasbourg only
Protects in relation to lawful strikes. If the strike's not properly balloted, isn't a trade dispute, or breaches any of the other labyrinthine rules, it's out. But the second complaint was about secondary action. And I just want to take a little care with going through the actual arguments here of the government, which set the context as to the court's decision on this. And if we can pick it up at paragraph 62, page 1071, you can see that the government accepted there that the right, Article 11 normally implied, but then the right to strike. But at 63, can I just ask the court to read the first 10 lines of that, because that's the government's argument. My lords and my lady, can I summarise it in this way? The government's argument was really based on a literal reading of Article 11. It was saying Article 11 talks of the right being for the protection of his interests. So they were saying solidarity action, secondary action, however you term it, wasn't protected, because then you weren't acting to protect your own members' interests. You were acting to protect the interests of another union's members. And you can see the virtue in that on the wording of Article 11. Now, the court rejects that if you look at paragraph 76 at page 1073. They refer to the Vienna Convention. They say it is derived from the literal reading of Article 11. They refer to the Vienna Convention.
Sorry, this is paragraph 70.
Paragraph 76.
76.
You can see they refer to that being a literal reading of Article 11, saying that secondary action is outside because it won't then be for the protection of his interests. They reject that argument, broadly speaking, because they say secondary action is protected by ILO conventions and the European Social Charter, and conclude at the end of 76, saying it would be inconsistent to adopt a narrow interpretation of Article 11. So they rejected the literal reading. But then the important, and say that the scope is wider, but then the important paragraph is 77. And we place particular emphasis on this as to interpreting what the court later decided. My lords and my ladies, what it's doing there is distinguishing secondary and primary action. It's saying primary action is a core aspect, whereas secondary action is an accessory aspect. In other words, it's rejected the government's argument, but nevertheless, it's biting on the potential that secondary strike action is a secondary aspect. Whereas primary action, because it's in defence of your own members' interests, is a core aspect. The reason why we draw attention to that is because these comments have got nothing to do, we say, with the public or private divide. It's nothing to do whether it's a vertical or a horizontal duty. It's to do with the nature of the strike action. Is it primary? Is the nature of the activity? Is it primary action in defence of your members' interests? Or is it secondary action when it's not? It then goes on, having noted at 82 that secondary action has much broader ramifications and can affect a wide range of interests when it comes to the legitimate aim, but it addresses necessity in a democratic society at 83 onwards. And the first thing to note is that at 84 it cites all the familiar cases which we set out in our case on individual sanctions on strikers. No questioning of them. It goes on at 85 to note that in this case, the members who were employed by Hydrex did exercise two of the critical elements because there was a primary strike. They exercised the right of the union to seek to persuade the employer and the right to engage in collective bargaining, exactly as here.
Can I ask you what you say about the last two sentences of 84?
Yes.
What are they? What you say about those?
Well, what they're saying is it's not one of the essential elements.
Does that have a bearing on what we have to decide here?
Well, we say no. Essential elements isn't the same as core and secondary aspects.
Sorry, what's essential if it isn't core?
Well, the essential elements are the rights to collective bargaining, the rights for the union to be heard, and the right to join. Those are all the essential elements.
Aren't they the core elements?
No, the two aren't synonymous in my respectful submission, my lady, no.
Something may be core without being essential.
Yes.
Yes.
Sorry, so can you just tell us what you say is core and what you say is essential?
Well, we say the core, I've mentioned the core relates to participation in trade union activities, including primary industrial action. The essential elements are those that I've already explained. Yeah.
Can you just repeat them?
The essential elements are the right to join and form, the right to seek to persuade the employer, and the right to engage in collective bargaining.
Not the freedom to protect the occupational interests of members by taking strike action. That's core, you say, not essential.
Well, it will be an exercise of two of those elements, because that's clear from 85. A primary strike is in exercise, is a means of exercising two of the essential elements. That's 85. And that's why it's core. Because Mrs. Mercer and Unison are the same as the members at Hydrex in relation to 85. They are exercising two of the essential elements. Now, then the court at 86 talks about how you assess the breadth of the margin. And it says 3/4 of the way down, it depends on factors the court in its case law has identified as relevant, including the nature and extent of the restriction, the object pursued, and the interests of others who are liable to suffer. And we say, when you examine this case is easy because we're on all fours with Karasay. The factors that are identified as relevant are an individual sanction intended to dissuade, and the competing rights of others have never been sufficient to displace that result. Next, the important paragraph 87, where again they go back to the core and secondary aspect distinction. And which is echoing the submission from the government that they've earlier rejected, because they are focusing on the nature of the trade union activity. In other words, a primary strike is a primary trade union activity exercising two of the essential elements, C85, whereas a secondary strike is a secondary aspect of trade union activity. See the comments when they rejected the government's submission earlier. And then that's picked up on when at 88 they conclude that the ban on secondary action didn't strike at the very substance of the applicant's freedom of association. That's at the bottom of 88 and over the page. On this ground, the case is to be distinguished from those referred to in paragraph 84 above, which all concerns restrictions on primary or direct industrial action by public sector employees, and the margin of appreciation to be recognised is the wider one, available in relation to regulation of the public interest of the secondary aspect of the trade union activities. Now, Mr. Stillitz, in his argument, places all of his weight on the reference to public sector employees. But we say, when you read it in the context of the argument they rejected and the earlier comments, it's clear the dividing line is not between public and private, it's between the core and secondary aspects of trade union activity. In summary, secondary action is a secondary aspect of trade union activity, precisely because the focus of Article 11 is on a union acting on its members' behalf to protect their interests. It remains a secondary activity regardless of whether the strike is against a public or private sector employer. A secondary strike in the public sector isn't a core trade union activity. We accept it's a secondary aspect. But conversely, a primary strike taken to defend the members' interests, occupational interests, is a core aspect of the trade union freedom protected by Article 11 to take action for the protection of his interests. See paragraph 85. So a primary strike is at the core, whether it's in the private sector or the public sector. So we say the words there just won't bear the weight that Mr. Stillitz is seeking to place on them. There was no reference to Danny Lenkov or any of these cases on the horizontal versus vertical, because, of course, this was just a challenge to legislation. So none of those cases arose. What the court is addressing there is the distinction between primary and secondary action. It's got nothing to do with the state versus private divide. And my lords and my lady, you'll note at 89, I haven't got time to go to it, but they looked at the object of the interference and referred to the extensive debates in Parliament in this case. Whereas we say in ours, there is no sufficiently important objective that could justify the absence of any protection against sanctions imposed on individuals short of dismissal, which dissuade them from participating in lawful strikes. At 1992-98 and onwards, the court said there were factors pointing in the other direction and referred to all the various international instruments. But they ended up concluding at 98 that on the particular facts of the case, that despite those international instruments, they weren't satisfied that on the particular facts of the case, there was an interference that those materials weren't, I can pick it up at the end of 98, of such persuasive weight for determining whether the operation of the statutory ban on secondary strikes, such as those complained of in the present case, was outside the range of permissible options. But here we say the position is very different, because all the international materials point in one clear direction, namely the state must provide real and effective protection against trade union members being subject to any detrimental treatment because of their membership of or activities, including sanctions because of participation in lawful strikes. And we've summarised those international principles in our case at 36 to 39, EF 77 to 79. And so far as I understand, they're not disputed. So we say on the assumed facts here, the UK is in clear breach of the position under ILO 98 and ESC Article 5. And on the facts of her case, contrast RMT, there's nothing to show anything other than a breach of Article 11. So pulling it all together at the end of RMT, and apologies if I'm being over repetitive here, we say RMT is about the margin of appreciation when it comes to circumscribing lawful industrial action, not about the protection of individuals who participate in the action. There is a wide margin that applies when the state sets the procedural and substantive restrictions on lawful industrial action. But the margin reduces to vanishing point when it comes to the protection of individuals.
So when it comes to
individuals who are acting within that perimeter. Secondly, there was no issue in RMT about the extent of the state's positive obligation because the challenge was to legislation. So we have no discussion of Danilenkov and the like, the cases which consistently state that the horizontal and vertical standards are the same when it comes to detrimental treatment on the basis of trade union activities. Thirdly, we say properly analysed, the judgment was focusing on the type of union activity and whether it is a primary trade union activity, that is a primary strike, or a secondary one. In other words, the margin varies as a function of the kind of activity, not whether it is in the public or private sphere. If Mrs. Mercer was an NHS care worker taking primary action, the sanction would be impermissible. The same applies when she's in the private sector. And fourthly, we say the distinction drawn by the Secretary of State is wrong for a fourth reason. The court in RMT, as you'll have noted, at 86, said you can look at the competing rights of those affected when considering justification or whether there's a legitimate aim. In general, of course, primary strikes in the private public sector affect a wider class of individuals and businesses than primary strikes in the private sector. So that indicates, if anything, a wider margin of appreciation when it comes to public sector strikes than when it comes to private sector strikes. And you don't need to take my word for that, because that's exactly what the government has said when it came recently to introducing minimum service levels. And if you can look in the supplemental bundle of authorities, beginning at page 81, as the court may be aware, very recently legislation has been passed requiring minimum services. Does my Lord Jones have the...
There's a problem, Mr. Mayor. Technical problem, Mr. Ford. Nothing to be concerned about. You carry on, please.
All right.
I've got one screen flickering, but
I'm very grateful,
the
my
other one's
Lord.
working.
Yes, if you wish, we have a hard copy. Would that assist of this?
It's the supplementary bundle.
Supplementary bundle, page 81, where they talk about the minimum services level bill. The government explains at 10 that before you, paragraph 10, page 82, that you need to show a pressing social need before restrictions on industrial action is justified.
Paragraph.
That's paragraph 10.
Thank you.
At 28, they say you must take into account provisions of the ILO, including in deciding whether or not you've breached the convention, which we, of course, echo. And then at 42, this. They say that the interference here is justified because it's necessary to protect the rights and freedom of others. Article 11 acknowledges there may be more stringent conditions imposed on certain public sectors. And that, of course, is reflected in the wording of Article 11.2, which talks about that. And they refer to the disruption caused by public sector strikes and the harm to the wider economy. And at 44, the European case law supports member states imposing more stringent restrictions on certain public sectors.
Those are about bans on particular groups of employees in the public sector participating altogether, aren't they?
Certainly they are, my lady, but it still illustrates the same point. When it comes to restrictions on individual strikers, there is no good, sufficient reason for saying you have to protect them when they're in the public sector, but in accordance with Daniel Lenkov, you don't in the private. So, my lords and my lady, in light of the time, I will pass quickly over some of the post-RMT cases. But in summary, we say TechGIDA, tab 31 EF 1147, that entirely supports our analysis. See paragraphs 51 and following. That when it comes to protection of the right to membership or activities, the protection is strict. It's a narrow margin of appreciation, nothing to do with the public or private divide. And you will note that in TechGIDA, there was also an issue in TechGIDA whether it made any difference whether the employer was in the public or private sector. And at paragraph 50, EF 155, the court said it doesn't matter. When it comes to the individual protection, it doesn't matter.
Which paragraph was that, sorry?
That's paragraph 50, page EF 155. Secondly, if we can just quickly look at Gula and Turkey, because Gula and Turkey is at EF 1024. Tab 25, so this is after RMT. I can't resist pointing this out. One of the judges was in fact in RMT. Judge Biancu was one of the judges in RMT. But we're back to paragraph 23. We're back to straightforward carousel. And lastly in the series, Ognevenko, which is at tab 27.
Sorry, Gula, was that a strike case or was it?
Yes, it was, yes. There was a dispute whether he'd been absent from work without leave or not, but you can see at 22, paragraph 22, they said the authorities could not have ignored the reason for his absence because the demonstration had been announced publicly. In other words, even though the authorities said, we're just disciplining you because you're absent without leave, the court says, no, the real reason was he was absent to take part in a strike. And we're back to all our old friends at paragraph 23. And very briefly, Ognevenko. Ognevenko in Russia, it's about a ban on strikes on the railway. Just for my lords and my ladies' notes, you'll see at 19 to 24. We have, once again, citation of all the ILO materials and the ESC. That's at page 10051 and following.
Sorry, Ognevenko.
Ognevenko, it begins at 1047.
Oh.
'56, they talk about the choice of a member state, but talk over the page, the granting of a right to strike constitutes without any doubt one of the most important means by which a union acts to protect
Sorry, where's that?
That's paragraph 56, EF 1055. '61, back to Eslan. The term restrictions embraces punitive measures taken afterwards, both ex ante and ex post facto. And the court rationalises its approach to sanctions in individual strike cases at yes, sorry, I should, just before 70, apologies, 70.
61 also talks about the right to strike being the means.
Yes, and similarly at 70, my lady, where they talk about is an important aspect and the right to form a trade union for that union to be heard. So in other words, it is an important aspect of the exercise of those essential elements.
Ford, if you'll forgive us, there is a technical problem. I think it's probably better if we rise for a few minutes so it can be sorted.
Of course, my lord.
Then we'll resume. Very sorry about this. Mr. Ford, I'm very sorry this should have happened. I think it's sorted out now. I hope so. Please don't think you'll be prejudiced as to time. It should have been necessary. We'll sit extra to
I'm
make it up. So
I'm
please
extremely
don't feel
grateful.
you've got to accelerate in making your submissions.
I'm extremely grateful, my lord, and I hope your computer's working. I think I was just on paragraph 70 of Ognovenko, which is at 1056. I've already shown you this, forgive me if I have, where again we're back to an important aspect of when it came to analysing whether or not there was a pressing social need. You will notice at paragraph 73 they said you would still require solid evidence from the state to justify the necessity of the restrictions. And the court pointed out in 76, by contrast to the position in RMT, there was no information, legislative history or parliamentary debates that explain this protection. And we say that's exactly the case here. There is no evidence that Parliament's ever considered the matter that we're raising before you. This isn't an area where there should be deference to the legislature a la animal defenders, because it's something that's never ever been considered by it. And the court rationalises the approach to individual sanctions at paragraph 83, which, if anyone can remember that long back, that was the paragraph cited in Straum. So it's pulling the threads all together, once again referring to the ILO and saying the court has previously found that such sanctions inevitably had a chilling effect on trade union members taking part in industrial action such as strikes to protect their professional interests. Precisely as Barris, precisely the wording of Article 11. That's the primary activity. That's what Article 11 protects. And we haven't got time to turn to it, but you'll see there's a dissent of Judge Dedoff. Can I invite the court, when reading this, to take out Judge Dedoff's arguments and simply insert Mr. Stillitz submits? Because in effect, this is Mr. Stillett's arguments. Wide margin, he goes on about RMT, says you're being terribly unfair. Look at paragraph 8 of his dissent. Look at paragraph 19, stress the breadth of the margin. So Judge Dedoff, we say, is Mr. Stillitz in another life. So in summary, my lords and my lady, the state may have a wide margin of appreciation in circumscribing lawful industrial action domestically, but once it's done so, individuals have to be protected against sanctions because of their participation in it, and that's our case. But can I quickly then turn to the case for the Secretary of State? Well, I must cover this before lunchtime. The first thing is paragraph 20 of their case, which is at page EF 116. Where they say there's no suggestion in the present case or in the judgments below the ability of an employer lawfully to dismiss striking workers under circumstances was incompatible with Article 11, nor was there any suggestion the exercise by an employer of common law remedies for breach of contract involved any such breach. Well, we don't accept that. To the extent the employer has a power to sue for damages on breach of contract, that's incompatible with Article 11C Dilek and Turkey. Equally, the common law remedy of summary dismissal isn't compatible with Article 11. And nor, for the avoidance of doubt, do we accept that the power under the domestic regime to dismiss in some circumstances is compatible with Article 11. This isn't that case, and it would need a whole raft of arguments about the scope of Article 11 and the whether or not Section 3 complied.
Sorry, you mentioned DILEC, and then you said equally the common law remedy of unfair dismissal.
Sorry, summary dismissal. My mistake, my lady. I apologise. The common law contractual power of summary dismissal. Yes.
You say is incompatible.
Yes. And as regards the circumstances in which they can be dismissed, well, there's already been the criticisms of the European Committee of Social Rights on the position in the UK. And
so I'm so sorry, Mr. Ford. Just going back to the common law power of summary dismissal, yes. that would be conditioned, wouldn't it, by the statutory yes. remedies that have stepped into the arena.
Of course.
So there is, one can dismiss.
Yes.
Subject to 238A and...
Precisely, my lady. The question would turn, are these statutory remedies sufficient compliance with Article 11?
But you're not advancing any case that they're not?
Well, we are not conceding they are.
Right.
But we say that that would be another case involving a whole raft of different arguments. But for what it's worth, the ILO CFA, for example, says the dismissal of strikers is a very serious violation of C98, and the European Committee on Social Rights has already said the 12-week protected period is arbitrary. But we're not here to argue that case.
So what's wrong with paragraph 20 is that it's correct to say there's no suggestion in this case, but you're just making clear that that is not, in any sense, a concession across the board. You might, well, in another case, wish to challenge whether the present regime of lawful dismissal is indeed contrary to Article 11.
Precisely, my lord. But I don't want to heap hypotheticals on hypotheticals. The heart of the respondent's, the Secretary of State's case, I should say, is set out at 53. Paragraph 57, rather, EF 128, which we've mostly covered, but I'll just give you some references. So their first argument is, well, it makes a difference whether the state's the employer. We say none of the cases support that distinction. When it comes to detrimental treatment of individuals because of trade union membership or activities, the standard is no different. And can I just give you the references? It goes back to Young, James and Webster on the closed shop. That's paragraph 75, EF 3003.
I'm sorry. So what's the reference?
Young, James and Webster, that's one of the very old cases on the closed shop, where even there was a dispute where the British Railway was in the private sphere. Paragraph 75, EF 3003. Wilson, we've already looked at, 48, EF 1177. Danilenkov 120 EF 894.
Sorry, Danilenkov 120
EF 894.
Thank you.
Syndicatal Pastoral Cell Bun, mispronounced.
Good Shepherd.
The Good
Shepherd.
Yes.
Paragraph 132 EF 1117. And Tech Gida, where there was also a dispute whether the employer was in the private sphere, paragraph 50, EF 1155. And while the Secretary of State cites various cases about different standards under Articles 2 and 8, at paragraphs 139, 83 to 85 of its case, we say with respect, those are, whatever the position is under those articles. In this context, trade union membership or activities, the duties are coextensive, whether it's direct interference or positive duty. The second argument for the Secretary of State at 57.2 is that when it comes to private employers, it's only if it's discrimination on grounds of trade union membership or the right to make representations on behalf of the union against which there must be protection. That's 57.2 EF 128.
Bear with us a moment. Yes.
And can we make 5 points in quick rebuttal? Firstly, this argument only gets off the ground if the Secretary of State is correct that there's a different standard applying when it comes to the positive duty versus direct interference. If those duties are the same as we submit, the point evaporates. Secondly, in support of that at paragraph 79 at EF 136, the Secretary of State says this: in reality, the key feature of her case is that she was subject to detriments in response to her engaging in industrial action, which the European Court of Human Rights has held to be a secondary or accessory aspect of trade union activity. That, we say, is a complete misreading of RMT. The court in RMT didn't say industrial action is a secondary or accessory activity. If it had done, the wider margin would apply in every case, even in a public sector case. And thirdly, and I'm afraid I'm going to have to give you a list of references here, nothing in the case law supports the distinction they are seeking to draw that the positive duty is only engaged where the restrictions target membership or making representatives on behalf of the union.
Sorry, can you say that a bit more slowly? It's probably just me, but
No, it's my fault. I'm hurrying.
It's hard to keep up.
Nothing in the case law supports the distinction they are seeking to draw that the state's positive duty is only engaged where the restrictions target trade union membership or making...
I'm sorry. This is important. It's important we get the point.
Yeah.
So nothing supports the distinction
between where the duty is, the positive duty is only engaged where the restrictions target trade union membership or making representations on behalf of the union. There is no such bright line. Participation in lawful trade union activities is a core aspect of membership. Its outward manifestation, if you will. and the cases have repeatedly rejected arguments that Article 11 is restricted to action targeting narrow membership or simply the right to have representations. And can I just give you the references for that? It dates back to the very early case of X and the Commission, where they said action against an official could impede the lawful exercise of freedom of association, and rejected the Irish government's argument that the only restriction, he wasn't prevented of forming or joining a union. That's EF 3015 to 16.
Paragraphs.
EF 30. I don't think there are paragraphs.
You've got the reference.
Yeah, it's such an ancient Commission decision. Secondly, the court will note there was no discussion in Wilson that it targeted his right to be a member. It had no, the disincentive had no effect on his membership. See paragraph 47, EF 1177. Ognevenko 83 EF 10057 on the inevitable chilling effect of sanctions, nothing about effect on membership or making representations to employer. A new authority, Zakharova and Russia, supplementary 65, where the chair and two members of a union were subject to harassment and discriminatory treatment because of their activity, and the court did not distinguish treatment based on activities or membership. See paragraph 35, supplemental 74 to 5, paragraph 42, supplemental 76. And lastly, in this sequence, C2, Caesar and Turkey, the one we emailed the translation, where a trade union official was reprimanded for attending a panel discussion as a union representative, a political discussion. Nothing to do with his right to join, nothing to do with him making representations to the employer. The court simply applies Karasay and says this was taken to dissuade him from taking part in lawful trade union activities, therefore impermissible.
And the reference to that?
The reference is paragraphs 40, 41 and 55. If you'll forgive me, my lord, we don't have a page reference because it's been emailed. Fourthly, the distinction drawn by the Secretary of State is inconsistent with the ESC and ILO materials, to which the court has repeatedly referred and relied, and upon which it's relied, and which draw no such distinction between membership and activities. See Danielenko and many others. Fifthly, we say the distinction is incoherent and inconsistent with the fundamental right which Article 11 protects. If an employer targets those who are active in the union with serious sanctions, so what if they're active in the union? So what if they've still got the right to be a member? So what if they're not personally involved in making representations? Article 11 protects the right to form and join a member for the protection of your interests, not just an empty right to be a member. And finally, it seems the Secretary of State accepts that restrictions on the right to make representations on behalf of a union do strike at the core. See 57.2. So the right to make representations apparently is one of the is on their case a core right. But we say the right to make representations or engage in collective bargaining, two of the essential elements, is devoid of substance if it's not backed by the right to take collective action. That's why the right to strike is one of the most important means by which the union protects the occupational interests. That's why it's an important aspect of the right for the union to be heard. Unless you protect the members against being sanctioned when they participate in it, the right to make representations becomes devoid of substance. And my lords and my lady, quickly picking up on the final points in their case. Paragraph 81. The absence of comprehensive protection plainly falls within the state's margin of appreciation. Well, as usual, we get the sprinkling of adverbs, but we say it adds nothing. The correct question is whether the absence of any real and effective protection in UK law for sanctions short of dismissal is compatible with Strasbourg. 81.1, there's a reference to Parliament choosing to strike the balance, or we say, by contrast to the position in RMT, and just like the Russian state in Ognyevenko, Parliament has not chosen to strike a balance here. It's never considered the issue. '88, by reference to Bank Mellet, this is EF 141. Again, back to the margin of appreciation, saying it's open to the state to provide some protection. They don't actually identify the aim, but we say Article 1 First Protocol rights aren't engaged when employers discipline or suspend employees. A contractual right to suspend isn't a possession. So there is no interference with A1P1 rights in an ordinary case. But in any case, the objective can't possibly be sufficient to restrict a fundamental right, because in every one of the Turkish cases, even on the assumption there was a legitimate aim, Karasay, Dilek, Erkan, Kaya, they said the inevitable chilling result meant the sanction was disproportionate. And we've explained in our case at paragraphs 54 and 56 why we say, as matters stand, there is no real or effective legal protection in the UK for those who are subject to detrimental treatment because of their participation in a lawful strike. My lords and my lady, I'll quickly draw to a close now, just on the Court of Appeal. We say the Court of Appeal got it wrong. If we can quickly turn to its judgment. At Divider 5, page 177. First of all, at paragraph 66, they agreed with Mr. Justice Chowdhury that if the positive obligation of the state was engaged, Danielenko establishes the positive obligation of the state is engaged in any case if the matters complained of result from a failure to secure the rights. For my lords and my ladies' notes, you can see that was dealt with by Mr. Justice Chowdhury at paragraphs 55 to 56, EF 2005, where he said it makes no difference, and we commend his judgment.
Sorry, which paragraphs? 55
55 and 56. Secondly, the Court of Appeal accepted that some matters had to be protected under Article 11. That was dismissal, paragraph 68. Actions for damages and suspension on nil pay, C70. But we say the Strasbourg cases have never focused on the seriousness of the sanction. They've simply said, if there's a sanction, however light, which is intended to dissuade, it's caught. And thirdly, to the extent the Court of Appeal was saying there's a different standard in the private versus the public sector, we say that's wrong for the reasons we've given. And so, at the end of my submissions on this point, all I'm really doing is saying we commend what we say is the impeccable analysis of Mr. Justice Chowdhury, paragraphs 47 to 69, EF 203 and following.
Sorry, Chowdhury, 47.
47 to 69, EF 203, 209.
Was Mr. Chowdhury focusing on just lawful strike activity?
Well, the amendment we proposed in front of him wasn't restricted to lawful, but we now accept that was a mistake on our part, that it has to in light of RMT and Trofimchuk, the Ukrainian case. It is only lawful industrial action.
Right, but when you're quoting paragraphs 47 to 69...
That's just his analysis of Article 11.
Right,
yeah.
And that doesn't... it's not important to you that in analysing that, the activity has to be lawful strike action?
Well, for the avoidance of doubt, we accept entirely that the protection of Article 11, based on the mirror principle, RMT and Trofimchuk, is only engaged when the strike is lawful under UK law.
And do you say that paragraph 71 of the Court of Appeal is problematic, or are you accepting that paragraph?
Well, we say it is problematic, or we'd say perhaps enigmatic is the word we'd use. I've seen problematic in too many academic articles, so I'll be careful with my jokes at that point. But they seem to be suggesting that the more serious the sanction, the more serious it then strikes at the core. We're not actually clear what they mean by the core there. But if they're saying, well, when it's a very serious sanction, it strikes at the core, but when it's a lesser sanction, it doesn't, we submit that's incoherent, that's implausible in light of the Strasbourg authorities. Because the Strasbourg authorities say if it's a core activity, which we say primary lawful industrial action is, it doesn't matter what sanctions engaged.
But it might be said that paragraph 71 on one reading supports your case.
Well, I think that's why I'm saying enigmatic.
Yeah.
They were clear, it seems. They didn't really explain what sanctions were caught, but they seem to be suggesting that it's only serious sanctions in the private sector which are precluded by Article 11. But with respect, we say there is no basis in the Strasbourg case law for that approach, and there is no basis in ILO Convention 98 or the ESC, which talk of any prejudicial treatment, or rather the decisions of the European Committee on Social Rights do.
You say if it strikes at the core of the trade union's activities, whether it's a public employer or a private employer, it's out.
Yeah, regardless of seriousness. There's no
No matter
foundation.
what the sanction is.
Exactly, there is no foundation for that in the Strasbourg case law. My lords and my lady, forgive me, I've gone on till...
Not at all.
Can I just ask one point that's slightly puzzling me? This whole issue is obviously of fundamental importance. There must have been commentaries or academic discussions of the sort of arguments that you're raising, but I don't think we've got any help in that respect, have we, or am I wrong?
Well, I don't want to denigrate your ex-colleagues, but I suspect to some extent they've been distracted by other arguments. I think one of the problems is that all these cases were only available in French. Yeah, so they only started really appearing after 2007.
So you're telling me there's no useful academic...
Well, I'll look at someone who knows better than I do.
Refuse to put it in the bundle.
I
Can I put
can't.
it this way? If there is anything, it would help if we could have it.
All right. But of course, Professor Bogg has written on this area, but I don't think it's, given he's appearing, I'm not sure it's proper for us to put.
It may be that it's Mr. Stillitz that will refer to that.
Well, whatever you think is appropriate to give us, I just think it would help to see a bigger picture.
Yeah, but it is odd that this area seems to have gone not particularly well heeded.
Yeah, thank you, Mr. Ford.
Thank you very much.
We'll resume at 2 o'clock. Thank you very much.